Hello, everyone. Today we're going to be reading Griswold v. Connecticut. Appellants, the executive director of the Planned Parenthood League of Connecticut and its medical director, a licensed physician, were convicted as accessories for giving married persons information and medical advice on how to prevent conception and, following examination, prescribing a contraceptive device or material for the wife's use. A Connecticut statute makes it a crime for any person to use any drug or article to prevent conception. Appellants claimed that the accessory statute, as applied, violated the 14th Amendment. An intermediate appellate court and the state's highest court affirmed the judgment. Held. 1. Appellants have standing to assert the constitutional rights of the married people. The Connecticut statute forbidding use of contraceptives violates the right of marital privacy, which is within the penumbra of specific guarantees of the Bill of Rights. This is amicus. Okay. Mr. Justice Douglas delivered the opinion of the court. Appellant Griswold is executive director of the Planned Parenthood League of Connecticut. Appellant Buxton is a licensed physician and a professor at the Yale Medical School who served as medical director for the league at its center in New Haven, a center open and operating from November 1st to November 10th of 1961, when appellants were arrested. They gave information, instruction, and medical advice to married persons as to the means of preventing conception. They examined the wife and prescribed the best contraceptive device or material for her use. Fees were usually charged, although some couples were serviced free. The statutes whose constitutionality is involved in this appeal are subsection 53-32 and 54-196 of the General Statutes of Connecticut. The former provides, any person who uses any drug, medicinal article, or instrument for the purpose of preventing conception shall be fined not less than $50 or imprisoned not less than 60 days, nor more than 1 year, or be both fined and imprisoned. Section 54-196 provides, any person who assists, abets, counsels, causes, hires, or commands another to commit any offense may be prosecuted and punished as if he were the principal offender. The appellants were found guilty as accessories and fined $100 each against the claim that the accessory statute, as so applied, violated the 14th Amendment. The appellate division of the Circuit Court affirmed. The Supreme Court of Errors affirmed that judgment. We noted probable jurisdiction. We think that appellants have standing to raise the constitutional rights of the married people with whom they had a professional relationship. Talston v. Ullman is different, for there the plaintiff seeking to represent others asked for a declaratory judgment. In that situation, we thought that the requirements of standing should be strict, lest the standards of case or controversy in Article 3 of the Constitution become blurred. Here, those doubts are removed by reason of a criminal conviction for serving married couples in violation of an aiding and abetting statute. Certainly, the accessory should have standing to assert that the offense which he is charged with assisting is not or cannot constitutionally be a crime. This case is more akin to Trow v. Reich, where an employee was permitted to assert the rights of his employer, to Pierce v. Society of Sisters, where the owners of private schools were entitled to assert the rights of potential pupils and their parents, and to Barrows v. Jackson, where a white defendant, party to a racially restrictive covenant, who was being sued for damages by the covenantors because she had conveyed her property to African Americans, was allowed to raise the issue that enforcement of the covenant violated the rights of prospective African American purchasers to equal protection, although no African American was a party to the suit. The rights of husband and wife pressed here are likely to be diluted or adversely affected unless those rights are considered in a suit involving those who have this kind of confidential relation to them. Coming to the merits, we are met with a wide range of questions that implicate the Due Process Clause of the 14th Amendment. Overtones of some arguments suggest that Lochner v. New York, which should be our guide. But we declined that invitation as we did in West Coast Hotel Company v. Parrish, Olson v. Nebraska, Lincoln Union v. Northwestern Co., Williamson versus Lee Optical, Gibney v. Empire Storage. We do not sit as a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems, business affairs, or social conditions. This law, however, operates directly on an intimate relation of husband and wife and their physician's role in one aspect of that relation. The association of people is not mentioned in the Constitution nor in the Bill of Rights. The right to educate a child in a school of the parent's choice, whether public or private or parochial, is also not mentioned, nor is the right to study any particular subject or any foreign language. Yet the First Amendment has been construed to include certain of those rights. By Pierce v. Society of Sisters, the right to educate one's children as one chooses is made applicable to the states by the force of the First and 14th Amendments. By Myers v. Nebraska, the same dignity is given the right to study the German language in a private school. In other words, the state may not, consistently with the spirit of the First Amendment, contract the spectrum of available knowledge. The right of freedom of speech and press includes not only the right to utter or to print, but the right to distribute, the right to receive, the right to read, and freedom of inquiry, freedom of thought, and freedom to teach. Indeed, the freedom of the entire university community. Without these peripheral rights, the specific rights would be less secure, and so we reaffirm the principle of the Pierce and the Meyer cases. In NAACP v. Alabama, we protected the freedom of association and privacy in one's associations, noting that freedom of association was a peripheral First Amendment right. Disclosure of membership lists of a constitutionally valid association we held was invalid as entailing the likelihood of a substantial restraint upon the exercise by petitioners members of their right to freedom of association. In other words, the First Amendment has a penumbra where privacy is protected from government intrusion. In like context, we have protected forms of association that are not political in the customary sense, but pertain to the social, legal, and economic benefits of the members. In Schwar v. Board of Bar Examiners, we held it is not permissible to bar a lawyer from practice because he had once been a member of the Communist Party. The man's association with that party was not shown to be anything more than a political faith in a political party, and was not action of a kind proving bad moral character. Those cases involved more than the right of assembly, a right that extends to all, irrespective of their race or ideology. The right of association, like the right of belief, is more than the right to attend a meeting. It includes the right to express one's attitudes or philosophies by membership in a group or by affiliation with it, or by other lawful means. Association in that context is a form of expression of opinion, and while it is not expressly included in the First Amendment, its existence is necessary in making the express guarantees fully meaningful. The foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. The right of association contained in the penumbra of the First Amendment is one, as we have seen. The Third Amendment, in its prohibition against the quartering of soldiers in any house in time of peace without the consent of the owner, is another facet of that privacy. The Fourth Amendment explicitly affirms the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fifth Amendment, in its self-incrimination clause, enables the citizen to create a zone of privacy which government may not force him to surrender to his detriment. The Ninth Amendment provides, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. The Fourth and Fifth Amendments were described in Boyd v. United States as protection against all government invasions of the sanctity of a man's home and the privacies of life. We recently referred in Mapp v. Ohio to the Fourth Amendment as creating a right to privacy no less important than any other right carefully and particularly reserved to the people. We have had many controversies over these penumbral rights of privacy and repose. These cases bear witness that the right of privacy which presses for recognition here is a legitimate one. The present case then concerns a relationship lying within the zone of privacy created by several fundamental constitutional guarantees, and it concerns a law which, in forbidding the use of contraceptives rather than regulating their manufacture or sale, seeks to achieve its goals by means of having a maximum destructive impact upon that relationship. Such a law cannot stand in light of the familiar principle so often applied by this court that a governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. We deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together, for better or for worse, hopefully enduring and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet it is an association for as noble a purpose as any involved in our prior decisions. Reversed. Mr. Justice Goldberg, whom the Chief Justice and Mr. Justice Brennan join concurring, I agree with the court that Connecticut's birth control law unconstitutionally intrudes upon the right of marital privacy, and I join in its opinion and judgment. Although I have not accepted the view that due process, as used in the 14th Amendment, incorporates all of the first 8 amendments, I do agree that the concept of liberty protects those personal rights that are fundamental and is not confined to the specific terms of the Bill of Rights. My conclusion that the concept of liberty is not so restricted and that it embraces the right of marital privacy through that right, though that right is not mentioned explicitly in the Constitution, is supported by numerous decisions of this court, referred to in the court's opinion, and by the language and history of the Ninth Amendment, in reaching the conclusion that the right of marital privacy is protected as being within the protected penumbra of specific guarantees of the Bill of Rights. The court refers to the Ninth Amendment. I add these words to emphasize the relevance of that amendment to the court's holding. The court stated many years ago that the Due Process Clause protected those liberties that are so rooted in the traditions and conscience of our people as to be ranked as fundamental. In Griswold v. New York, the court said, "For present purposes, we may and do assume that freedom of speech and of the press, which are protected by the First Amendment from abridgment by Congress, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states." And in Meyer v. Nebraska, the court referring to the 14th Amendment stated, "While this court has not attempted to define with exactness the liberties thus guaranteed, the term has received much consideration, and some of the included things have been definitely stated. Without doubt, it denotes not merely freedom from bodily restraint, but also, for example, the right to marry, establish a home, and bring up children." This court, in a series of decisions, has held that the 14th Amendment absorbs and applies to the states those specifics of the first eight amendments which express fundamental personal rights. The language and history of the Ninth Amendment reveal that the framers of the Constitution believed that there are additional fundamental rights protected from government infringement which exist alongside those fundamental rights specifically mentioned in the first 8 constitutional amendments. The Ninth Amendment reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people." The amendment almost entirely the work of James Madison. It was introduced in Congress by him and passed the House and Senate with little or no debate and virtually no change in language. It was proffered to quiet expressed fears that a bill of specifically enumerated rights could not be sufficiently broad to cover all essential rights, and that the specific mention of certain rights would be interpreted as a denial that others were protected. In presenting the proposed amendment, Madison said, It has to be objected also against a Bill of Rights that, by enumerating particular exceptions to the grant of power, it would disparage those rights which were not placed in that enumeration, and it might follow by implication that those rights which were not singled out were intended to be assigned into the hands of the general government and were consequently insecure. This is one of the most plausible arguments I have ever heard urged against the admission of a Bill of Rights into the system, but I conceive that it may be guarded against. I have attempted it, as gentlemen may see by turning to the last clause of the fourth resolution, the Ninth Amendment. Mr. Justice Story wrote of this argument against the Bill of Rights and the meaning of the Ninth Amendment. In regard to a suggestion that the affirmance of certain rights may disparage others or might lead to argumentative implications in favor of other powers, it might be sufficient to say that such a course of reasoning could never be sustained upon any solid basis. But a conclusive answer is that such an attempt may be interdicted, as it has been, by a positive declaration in such a Bill of Rights that the enumeration of certain rights shall not be construed to deny or disparage others retained by the people. He further stated, referring to the Ninth Amendment, this clause was manifestly introduced to prevent any perverse or ingenious misapplication of the well-known maxim that an affirmation in particular cases implies a negation in all others, and a converso, that a negation in particular cases implies an affirmation in all others. These statements of Madison and Story make clear that the framers did not intend that the first 8 amendments be construed to exhaust the basic and fundamental rights which the Constitution guaranteed to the people. While this court has had little occasion to interpret the Ninth Amendment, it cannot be presumed that any clause in the Constitution is intended to be without effect. In interpreting the Constitution, real effect should be given to all the words it uses. The Ninth Amendment to the Constitution may be regarded by some as a recent discovery and may be forgotten by others, but since 1791 it has been a basic part of the Constitution which we are sworn to uphold. To hold that a right so basic and fundamental and so deep-rooted in our society as the right of privacy in marriage may be infringed because that right is not guaranteed in so many words by the first 8 amendments to the Constitution is to ignore the Ninth Amendment and to give it no effect whatsoever. Moreover, a judicial construction that this fundamental right is not protected by the Constitution because it is not mentioned in explicit terms by one of the first 8 amendments or elsewhere in the Constitution would violate the Ninth Amendment, which specifically states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. A dissenting opinion suggests that my interpretation of the Ninth Amendment somehow broadens the power of this court. With all due respect, I believe that it misses the import of what I am saying. I do not take the position of my brother Black in his dissent in Adamson v. California, that the entire Bill of Rights is incorporated in the 14th Amendment, and I do not mean to imply that the Ninth Amendment is applied against the states by the 14th. Nor do I mean to state that the Ninth Amendment constitutes an independent source of rights protected from infringement by either the states or the federal government. Rather, the Ninth Amendment shows a belief of the Constitution's authors that fundamental rights exist that are not expressly enumerated in the first 8 amendments, and an intent that the list of rights included there not be deemed exhaustive. As any student of this court's opinions knows, this court has held, often unanimously, that the 5th and 14th Amendments protect certain fundamental liberties from abridgment by the federal government or the states. The Ninth Amendment simply shows the intent of the Constitution's authors that other fundamental personal rights should not be denied such protection or disparaged in any other way simply because they are not specifically listed in the first 8 constitutional amendments. I do not see how this broadens the authority of the court. Rather, it serves to support what the court has been doing in protecting fundamental rights. Nor am I turning somersaults with history in arguing that the Ninth Amendment is relevant in a case dealing with a state's infringement of a fundamental right. While the Ninth Amendment, and indeed the entire Bill of Rights, originally concerned restrictions upon federal power, the subsequently enacted 14th Amendment prohibits the states as well from abridging fundamental personal liberties. And the Ninth Amendment is in indicating that not all such liberties are specifically mentioned in the first 8 amendments is surely relevant in showing the existence of other fundamental personal rights, now protected from state as well as federal infringement. In sum, the Ninth Amendment simply lends strong support to the view that the liberty protected by the Fifth and 14th Amendments from infringement by the federal government or the states is not restricted to rights specifically mentioned in the first 8 amendments. In determining which rights are fundamental, judges are not left at large to decide cases in light of their personal and private notions. Rather, they must look to the traditions and collective conscience of our people to determine whether the principle is so rooted there as to be ranked fundamental. The inquiry is whether a right involved is of such a character that it cannot be denied without violating those fundamental principles of liberty and justice which lie at the base of all our civil and political institutions. Liberty also gains content from the emanations of specific constitutional guarantees and from experience with the requirements of a free society. I agree fully with the court that applying these tests, the right of privacy is a fundamental personal right emanating from the totality of the constitutional scheme under which we live. Mr. Justice Brandeis, dissenting in Olmstead v. United States, comprehensively summarized the principle underlying the Constitution's guarantees of privacy. The protection guaranteed by the Fourth and Fifth Amendments is much broader in scope. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred, as against the government, the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. The Connecticut statutes here involved deal with a particularly important and sensitive area of privacy, that of the marital relation and the marital home. This court recognized in Meyer v. Nebraska that the right to marry, establish a home, and bring up children was an essential part of the liberty guaranteed by the 14th Amendment. In Pierce v. Society of Sisters, the court held unconstitutional an Oregon Act which forbade parents from sending their children to private schools because such an act unreasonably interferes with the liberty of parents and guardians to direct the upbringing and education of children under their control. As this court said in Prince v. Massachusetts, the Meyer and Pierce decisions have respected the private realm of family life which the state cannot enter. I agree with Mr. Justice Harlan's statement in his dissenting opinion in Poe v. Ullman. Certainly, the safeguarding of the home does not follow merely from the sanctity of property rights. The home derives its preeminence as the seat of family life, and the integrity of that life is something so fundamental that it has been found to draw to its protection the principles of more than one explicitly granted constitutional right. Of this whole private realm of family life, it is difficult to imagine what is more private or more intimate than a husband and a wife's marital relations. The entire fabric of the Constitution and the purposes that clearly underlie its specific guarantees demonstrate that the rights of marital privacy and to marry and raise a family are of similar order and magnitude as the fundamental rights specifically protected. Although the Constitution does not speak in so many words of the right to privacy in marriage, I cannot believe that it offers these fundamental rights no protection. The fact that no particular provision of the Constitution explicitly forbids the state from disrupting the traditional relation of the family, a relation as old as as fundamental as our entire civilization, surely does not show that the government was meant to have the power to do so. Rather, as the Ninth Amendment expressly recognizes, there are fundamental personal rights, such as this one, which are protected from abridgment by the government, though not specifically mentioned in the Constitution. My brother Stuart, while characterizing the Connecticut birth control law as an uncommonly silly law, would nevertheless let it stand on the ground that it is not for the courts to substitute their social and economic beliefs for the judgment of legislative bodies who are elected to pass laws. Elsewhere, I have stated that while I quite agree with Mr. Justice Brandeis that a state may serve as a laboratory and try novel social and economic experiments, I do not believe that this includes the power to experiment with the fundamental liberties of citizens. The vice of the dissenters' views is that it would permit such experimentation by the states in the area of the fundamental personal rights of its citizens. I cannot agree that the Constitution grants such power either to the states or to the federal government. The logic of the dissents would sanction federal or state legislation that seems to me even more plainly unconstitutional than the statute before us. Surely the government, absent a showing of a compelling subordinating state interest, could not decree that all husbands and wives must be sterilized after two children have been born to them. Yet by their reasoning, such an invasion of marital privacy would not be subject to the constitutional challenge because, while it might be silly, no provision of the Constitution specifically prevents the government from curtailing the marital right to bear children and raise a family. While it may shock some of my brethren that the court today holds that the Constitution protects the right of marital privacy, in my view, it is far more shocking to believe that the personal liberty guaranteed by the Constitution does not protect does not include protection against such totalitarian limitation of family size, which is as complete variance with our constitutional concepts. Yet, if upon a showing of a slender basis of rationality, a law outlawing voluntary birth control by married persons is valid, then, by the same reasoning, a law requiring compulsory birth control also would be seen to be valid. In my view, however, both types of laws would unjustifiably intrude upon rights of marital privacy, which are constitutionally protected. In a long series of cases, this court has held that where fundamental personal liberties are involved, they may not be abridged by the states simply on the showing that a regulatory statute has some rational relationship to the effectuation of a proper state purpose. Where there is a significant encroachment upon personal liberty, the state may prevail only upon showing a subordinating interest which is compelling. The law must be shown to be necessary and not merely rationally related to the accomplishment of a permissible state policy. Although the Connecticut birth control law obviously encroaches upon a fundamental personal liberty, the state does not show that the law serves any subordinating state interest which is compelling or that it is necessary to the accomplishment of a permissible state policy. The state at most argues that there is some rational relation between this statute and what is admittedly a legitimate subject of state concern, the discouraging of extramarital relations. It says that preventing the use of birth control devices by married persons helps prevent the indulgence by some in such extramarital relations. The rationality of this justification is dubious, particularly in light of the admitted widespread availability of all persons in the state of Connecticut, unmarried as well as married, of birth control devices for the prevention of disease, as distinguished from the prevention of conception. But in any event, it is clear that the state interest in safeguarding marital fidelity can be served by a more discriminately tailored statute, which does not, like the present one, sweep unnecessarily broadly, reaching far beyond the evil sought to be dealt with and intruding upon the privacy of all married couples. Here, as elsewhere, precision of regulation must be the touchstone in an area so closely touching our most precious freedoms. The state of Connecticut does have statutes, the constitutionality of which is beyond doubt, which prohibit adultery and fornication. These statutes demonstrate that means for achieving the same basic purposes of protecting marital fidelity are available to Connecticut without the need to invade the area of protected freedoms. Finally, it should be said of the court holding today that it in no way interferes with the state's proper regulation of sexual promiscuity or misconduct. As my brother Harlan so well stated in his dissenting opinion in Poe v. Ullman, adultery, homosexuality, and the like are sexual intimacies which the state forbids, but the intimacy of husband and wife is necessarily an essential and accepted feature of the institution of marriage, and an institution which the state not only must allow, but which always and in every age it has fostered and protected. It is one thing when the state exerts its power either to forbid extramarital sexuality or to say who may marry, but it is quite another when, having acknowledged a marriage and the intimacies inherent in it, it undertakes to regulate by means of the criminal law the details of that intimacy. In sum, I believe that the right of privacy in the marital relation is fundamental and basic, a personal right retained by the people within the meaning of the Ninth Amendment. The Connecticut Connecticut cannot constitutionally abridge this fundamental right, which is protected by the 14th Amendment, from infringement by the states. I agree with the court that the petitioner's convictions must therefore be reversed. Mr. Justice Harlan, concurring in the judgment. I fully agree with the judgment of reversal, but find myself unable to join the court's opinion. The reason is that it seems to me to evince an approach to this case very much like that taken by my brother Black and Stewart in dissent. Namely, the Due Process Clause of the 14th Amendment does not touch this Connecticut statute unless the enactment is found to violate some basic right assured by the letter or penumbra of the Bill of Rights. In other words, what I find implicit in the court's opinion is that the incorporation doctrine may be used to restrict the reach of the 14th Amendment Due Process Clause. For me, this is just as unacceptable constitutional doctrine as it is the use of the incorporation approach to impose upon the states all the requirements of the Bill of Rights as found in the provisions of the first 8 amendments and in the decisions of this court interpreting them. In my view, the proper constitutional inquiry in this case is whether the Connecticut statute infringes the Due Process Clause of the 14th Amendment. Because the enactment violates basic values implicit in the concept of ordered liberty, for reasons stated at length in my dissenting opinion in Poe v. Ullman, I believe that it does. While the relevant inquiry may be aided by resort to one or more of the provisions of the Bill of Rights, it is not dependent on them or any of their radiations. The Due Process Clause of the 14th Amendment stands, in my opinion, on its own bottom. A further observation seems in order respecting the justification of my brother Black and Stewart for their incorporation approach to this case. Their approach does not rest on historic reasons, which are of course wholly lacking, but on the thesis that by limiting the content of the Due Process Clause of the 14th Amendment to the protection of rights which can be found elsewhere in the Constitution, in this instance in the Bill of Rights, judges will thus be confined to interpretation of specific constitutional provisions and will thereby be restrained from introducing their own notions of constitutional right and wrong into the vague contours of the Due Process Clause. While I could not more heartily agree that judicial self-restraint is an indispensable ingredient of sound constitutional adjudication, I do submit that the formula suggested for achieving it is more hollow than real. Specific provisions of the Constitution, no less than due process, lend themselves as readily to personal interpretations by judges whose constitutional outlook is simply to keep the Constitution in supposed tune with the times. Need one go further than to recall last term's reapportionment cases, Westbury v. Sanders and Reynolds v. Sims, where a majority of the court interpreted by the people an equal protection to command one person, one vote, an interpretation that was made in the face of irrefutable and still unanswered history to the contrary. See my dissenting opinion in those cases. Judicial self-restraint will not, I suggest, be brought about in the due process area by the historically unfounded incorporation formula long advanced by my brother Black and now in part espoused by my brother Stewart. It will be achieved in this area, as in other constitutional areas, only by continual insistence upon respect for the teachings of history, solid recognition of the basic values that underlie our society, and wise appreciation of the great roles that the doctrines of federalism and separation of powers have played in establishing and preserving American freedoms. Adherence to these principles will not, of course, obviate all constitutional differences of opinion among judges, nor should it. Their continued recognition will, however, go farther toward keeping most judges from roaming at large in the constitutional field than will the interpolation into the Constitution of an artificial and largely illusory restriction on the content of the Due Process Clause. Mr. Justice White, concurring in the judgment. In my view, this Connecticut law, as applied to married couples, deprives them of liberty without due process of law, as that concept is used in the 14th Amendment. I therefore concur in the judgment of the court reversing these convictions under Connecticut's aiding and abetting statute. It would be unduly repetitious and belaboring the obvious to expound on the impact of this statute on the liberty guaranteed by the 14th Amendment against arbitrary and capricious denials, or on the nature of this liberty. Suffice it to say that this is not the first time this court has had the occasion to articulate that the liberty entitled to protection under the 14th Amendment includes the right to marry, establish a home, and bring up children. and the liberty to direct the upbringing and education of children, and that these are among the basic civil rights of man. These decisions affirm that there is a realm of family life which the state cannot enter without substantial justification. Surely the right invoked in this case to be free of regulation of the intimacies of the marriage relationship comes to this court with a momentum for respect lacking when appeal is made to liberties which derive merely from shifting economic arrangements. The Connecticut anti-contraceptive statute deals rather substantially with this relationship, for it forbids all married persons the right to use birth control devices, regardless of whether their use is dictated by considerations of family planning, health, or indeed even of life itself. The anti-use statute, together with the general aiding and abetting statute, prohibits doctors from affording advice to married persons on proper and effective methods of birth control. And the clear effect of these statutes, as enforced, is to deny disadvantaged citizens of Connecticut, those without either adequate knowledge or resources, to obtain private counseling, access to medical assistance, and up-to-date information in respect to proper methods of birth control. In my view, a statute with these effects bears a substantial burden of justification when attacked under the 14th Amendment. An examination of the justification offered, however, cannot be avoided by saying that the Connecticut anti-use statute invaded a protected area of privacy and association, or that it demeans the marriage relationship. The nature of the right invaded is pertinent, to be sure, for statutes regulating sensitive areas of liberty do, under the cases of this court, require strict scrutiny and must be viewed in the light of less drastic means of achieving the same basic purpose. Where there is a significant encroachment upon personal liberty, the state may prevail only upon showing a subordinating interest which is compelling. But such statutes, if reasonably necessary for the effectuation of a legitimate and substantial state interest, and not arbitrary and capricious in application, are not invalid under the Due Process Clause. As I read the opinions of the Connecticut courts and the argument of Connecticut in this court, the state claims but one justification for its anti-use statute. There is no serious contention that Connecticut thinks the use of artificial or external methods of contraception immoral or unwise in itself, or that the anti-use statute is founded upon any policy of promoting population expansion. Rather, the statute is said to serve the state's policy against all forms of promiscuous or illicit sexual relationships, be they premarital or extramarital, conceitedly a permissible and legitimate legislative goal. Without taking issue with the premise that the fear of conception operates as a deterrent to such relationships, in addition to the criminal prescriptions Connecticut has against such conduct, I wholly fail to see how the ban on the use of contraceptives by married couples in any way reinforces the state's ban on illicit sexual relationships. Connecticut does not bar the importation or possession of contraceptive devices. They are not considered contraband material under state law, and their availability in that state is not seriously disputed. The only way Connecticut seeks to limit or control the availability of such devices is through its general aiding and abetting statute, whose operation in this context has been quite obviously ineffective and whose most serious use has been against birth control clinics rendering advice to married rather than unmarried persons. Indeed, after over 80 years of the state's proscription of use, the legality of the sale of such devices to prevent disease has never been expressly passed upon, although it appears that sales have long occurred and have only infrequently been challenged. This undeviating policy throughout all the long years bespeaks more than prosecutorial paralysis. Moreover, it would appear that the sale of contraceptives to prevent disease is plainly legal under Connecticut law. In these circumstances, one is rather hard-pressed to explain how the ban on use by married persons in any way prevents use of such devices by persons engaging in illicit sexual relations, and thereby contributes to the state's policy against such relationships. Neither the state courts nor the state before the bar of this court has tendered such an explanation. It is purely fanciful to believe that the broad prescription on use facilitates discovery of use by persons engaging in a prohibited relationship, or for some other reason makes such use more unlikely, and thus can be supported by any sort of administrative consideration. Perhaps the theory is that the flat ban on use prevents married people from possessing contraceptives, and without the ready availability of such devices for use in the marital relationship, there will be no or less temptation to use them in extramarital ones. This reasoning rests on the premise that married people will comply with the ban in regard to their marital relationship, notwithstanding total non-enforcement of this in this context and apparent non-enforceability, but will not comply with the criminal statutes prohibiting extramarital affairs and the anti-use statute in respect to illicit sexual relationships, a premise whose validity has not been demonstrated and whose intrinsic validity is not very evident. In most, at most, the broad ban is of marginal utility to the declared objective. A statute limiting its prohibition on use to persons engaged in the prohibited relationship would serve the end posited by Connecticut in the same way and with the same effectiveness or ineffectiveness as the broad anti-use statute under attack in this case. I find nothing in this record justifying the sweeping scope of this statute, with its telling effect on the freedom of married persons, and therefore concludes that it deprives such persons of liberty without due process of law. Mr. Justice Black, with whom Mr. Justice Stewart joins dissenting. I agree with my brother Stewart's dissenting opinion, and like him, I do not to any extent whatever base my view that this Connecticut law is constitutional on a belief that the law is wise or that its policy is a good one. In order that there may be no room at all to doubt why I vote as I do, I feel constrained to add that the law is every bit as offensive to me as it is to my brethren of the majority and my brothers Harlan, White, and Goldberg, who, reciting reasons why it is offensive to them, hold it unconstitutional. There is no single one of the graphic and eloquent strictures and criticisms fired at the policy of this Connecticut law, either by the court's opinion or by those of my concurring brethren, to which I cannot subscribe, except their conclusion that the evil qualities they see in the law make it unconstitutional. Had the doctor defendant here, or even the non-doctor defendant, been convicted for doing nothing more than expressing opinions to persons coming to the clinic that certain contraceptive devices, medicines, or practices would do them good to and would be desirable, and or for telling people how devices could be used, I can think of no reasons at this time why their expressions of views would not be protected by the First and 14th Amendments, which guarantee freedom of speech. But speech is one thing, conduct and physical activities are quite another. The two defendants here were active participants in an organization which gave physical examinations to women, advised them what kind of contraceptive devices or medicines would most likely be satisfactory for them, and then supplied the devices themselves, all for the graduated scale of fees based on the family income. Thus, these defendants admittedly engaged with others in a planned course of conduct to help people violate the Connecticut law, merely because some speech was used in carrying out that conduct. Just as in ordinary life, some speech accompanies most kinds of conduct, we are not, in my view, justified in holding that the First Amendment forbids the state to punish their conduct. Strongly as I desire to protect all First Amendment freedoms, I am unable to stretch the amendment so as to afford protection to the conduct of these defendants in violating the Connecticut law. What would be the constitutional fate of the law if hereafter applied to punish nothing but speech is, as I have said, quite another matter. The court talks about a constitutional right of privacy as though there is some constitutional provision or provisions forbidding any law ever to be passed which might abridge the privacy of individuals. But there is not. There are, of course, guarantees in certain specific constitutional provisions which are designed in part to protect privacy at certain times and places with respect to certain activities. Such, for example, is the Fourth Amendment's guarantee against unreasonable searches and seizures. But I think it belittles the amendment to talk about it as though it protects nothing but privacy. To treat it that way is to give it a bad interpretation, not the kind of liberal reading I think any Bill of Rights provision should be given. The average man would very likely not have his feelings soothed anymore by having his property seized openly than by having it seized privately and by stealth. He simply wants his property left alone. And a person can be just as much, if not more, irritated, annoyed, and injured by an unceremonious public arrest by a policeman as he is by a seizure in the privacy of his home or office. One of the most effective ways of diluting or expanding a constitutionally guaranteed right is to substitute for the crucial word or words of the constitutional guarantee another word or words more or less flexible and more or less restricted in meaning. The fact is well illustrated by the use of the term right of privacy as a comprehensive substitute for the Fourth Amendment's guarantee against unreasonable searches and seizures. Privacy is a broad, abstract, and ambiguous concept which can easily be shrunken in meaning, but which can also, on the other hand, easily be interpreted as a constitutional ban against many things other than searches and seizures. I have expressed the views that many times that First Amendment freedoms, for example, have suffered from a failure of the court to stick to the simple language of the First Amendment in construing it. Instead, instead of invoking multitudes of words substituted for those of the framers used, for these reasons, I get nowhere in this case by talk about constitutional right of privacy as an emanation from one or more constitutional provisions. I like my privacy as well as the next one, but I am nevertheless compelled to admit that government has a right to invade my privacy, to invade it, unless prohibited by some specific constitutional provision. For these reasons, I cannot agree with the court's judgment and the reasoning it gives for holding the Connecticut law unconstitutional. This brings me to the arguments made by my brothers Harlan, White, and Goldberg for invalidating the Connecticut law. Brothers Harlan and White would invalidate it by reliance on the Due Process Clause of the 14th Amendment, but Brother Goldberg, while agreeing with Brother Harlan, relies also on the 9th Amendment. I have no doubt that the Connecticut law could be applied in such a way as to abridge the freedom of speech and press and therefore violate the 1st and 14th Amendments. My disagreement with the court's opinion holding that there is such a violation here is a narrow one relating to the application of the First Amendment to the facts and circumstances of this particular case. But my disagreement with brothers Harlan, White, and Goldberg is more basic. I think that if properly construed, neither the Due Process Clause nor the Ninth Amendment, nor both together, could under any circumstances be a proper basis for invalidating the Connecticut law. I discussed the Due Process and Ninth Amendment arguments together because, on analysis, they turn out to be the same thing, merely using different words to claim for this court and the federal judiciary power to invalidate any legislative act which the judges find irrational, unreasonable, or offensive. The due process argument which my brother Harlan and White adopt here is based, as their opinions indicate, on the premise that this court is vested with power to invalidate all state laws that it considers to be arbitrary, capricious, unreasonable, or oppressive, or on this court's belief that a particular state law under scrutiny has no rational or justifying purpose, or is offensive to a sense of fairness and justice. If these formulas based on natural justice, or others which mean the same thing, are to prevail, they require judges to determine what is or is not constitutional on the basis of their own appraisal of what laws are unwise or unnecessary. The power to make such decisions is, of course, that of a legislative body. Surely it has to be admitted that no provision of the Constitution specifically gives such blanket power to the courts to exercise such a supervisory veto over the wisdom and value of legislative policies and to hold unconstitutional those laws which they believe unwise or dangerous. I readily admit that no legislative body, state or national, should pass laws that can justly be given any of the invidious labels invoked as constitutional excuses to strike down state laws. But perhaps it is not too much to say that no legislative body ever does pass laws without believing that they will accomplish a sane, rational, wise, and justifiable purpose. While I completely subscribe to the holding in Marbury v. Madison and subsequent cases that our court has constitutional power to strike down statutes, state or federal, that violate command of the federal Constitution, that violate the commands of the federal Constitution, I do not believe that we are granted power by the Due Process Clause or any other constitutional provision or provisions to measure constitutionality by our belief that legislation is arbitrary, capricious, or unreasonable, or accomplishes no justifiable purpose, or if offensive to our own notions of civilized standards of conduct. Such an appraisal of the wisdom of legislation is an attribute of the power to make laws, not of the power to interpret them. The use by federal courts of such a formula or doctrine or whatnot to veto federal or state laws simply takes away from Congress and states the power to make laws based on their own judgments of fairness and wisdom and transfers that power to this court for ultimate determination, a power which was specifically denied to federal courts by the convention that framed the Constitution. Of these cases on which my brothers White and Goldberg rely so heavily, undoubtedly the reasoning of two of them supports their results here, as would uh, as would that of a number of others which they do not bother to name. Whoops, too far. The two they do cite and quote from Myers v. Nebraska and Pierce v. Society of Sisters were both decided in the opinions of Mr. Justice McReynolds, which elaborated the same natural law due process philosophy found in Lochner v. New York, one of the cases on which he relied in Meyer, along with such other long discredited decisions. Meyer held unconstitutional as an arbitrary and unreasonable interference with the right of a teacher to carry on his occupation and of parents to hire him, a state law forbidding the teaching of modern foreign languages to young children in the schools. And in Pierce, relying principally on Meyer, Mr. Justice McReynolds said that a state law requiring that all children attend public schools interfered unconstitutionally with the property rights of private school corporations because it was an arbitrary, unreasonable, and unlawful interference, which threatened destruction of their business and property. Without expressing an opinion as to whether either of those cases reached a correct result in light of our later decisions applying the First Amendment to the states through the 14th, I merely point out that the reasoning stated in Meyer and Pierce was the same natural law due process philosophy which many later opinions repudiated, and which I cannot accept. Brothers White and Goldberg also cite other cases, such as NAACP v. Button, Shelton v. Tucker, and Schneider v. State, which held that states in regulating conduct could not, consistently with the First Amendment as applied to them by the 14th, pass unnecessarily broad laws which might indirectly infringe on First Amendment freedoms. Brothers White and Goldberg now apparently would start from this requirement that laws be narrowly drafted so as not to curtail free speech and assembly and extend it limitlessly to require states to justify any law restricting liberty as my brethren define liberty. This would mean at the very least, I suppose, that every state criminal statute, since it must inevitably curtail liberty to some extent, would be suspect and would have to be justified to this court. My brother Goldberg has adopted the recent discovery that the Ninth Amendment, as well as the Due Process Clause, can be used by this court as authority to strike down all state legislation which this court thinks violates fundamental principles of liberty and justice or is contrary to the traditions and collective conscience of our people. He also states, without proof satisfactory to me, that in making decisions on this basis, judges will not consider their personal and private notions. One may ask how they can avoid considering them. Our court certainly has no machinery with which to take a Gallup poll, and the scientific miracles of this age have not yet produced a gadget which the court can use to determine what traditions are rooted in the collective conscience of our people. Moreover, one would certainly have to look far beyond the language of the Ninth Amendment to find that the framers vested in this court any such awesome veto powers over lawmaking, either by the states or by the Congress. Nor does anything in the history of the amendment offer any support for such a shocking doctrine. The whole history of the adoption of the Constitution and Bill of Rights points the other way, and the very material quoted by my brother Goldberg shows that the Ninth Amendment was intended to protect against the idea that by enumerating particular exceptions to the grant of power to the federal government, those rights were not singled out, were intended to be assigned to the hands of the general government, the United States, and were consequently insecure. That amendment was passed not to broaden the power of this court or any other department of the general government, but as every student of history knows, to assure the people that the Constitution, in all its provisions, was intended to limit the federal government to the powers granted expressly or by necessary implication. If any broad, unlimited power to hold laws unconstitutional because they offend what this court conceives to be the collective conscience of our people is vested in this court by the Ninth Amendment, the 14th Amendment, or any other provision of the Constitution, it was not given by the framers, but rather has been bestowed on the court by the court. This fact is perhaps responsible for the peculiar phenomenon that for a period of a century and a half, no serious suggestion was ever made that the Ninth Amendment, enacted to protect state powers against federal invasion, could be used as a weapon of federal power to prevent state legislators from passing laws they considered appropriate to govern local affairs. Use of any such broad, unbounded judicial authority would make of this court's members a day-to-day constitutional convention. I repeat, so as not to be misunderstood, that this court does have power, which it should exercise, to hold laws unconstitutional where they are forbidden by the federal Constitution. My point is that there is no provision of the Constitution which either expressly or impliedly vests power in this court to sit as a supervisory agency over acts of duly constituted legislative bodies and set aside their laws because of the court's belief that the legislative policies adopted are unreasonable, unwise, arbitrary, capricious, or irrational. The adoption of such a loose, flexible, uncontrolled standard for holding laws unconstitutional, if ever it is finally achieved, will amount to a great unconstitutional shift of power to the courts, which I believe and am constrained to say will be bad for the courts and worse for the country. Subjecting federal and state laws to such an unrestrained and unrestrainable judicial control as to the wisdom of legislative enactments would, I fear, jeopardize the separation of governmental powers that the framers set up and at the time threatened to take away much of the power of states to govern themselves which the Constitution plainly intended them to have. I realize that many good and able men have eloquently spoken and written, sometimes in rhapsodical strains, about the duty of this court to keep the Constitution in tune with the times. The idea is that the Constitution must be changed from time to time, and that this court is charged with a duty to make those changes. For myself, I must with all deference reject that philosophy. The Constitution makers knew the need for change and provided for it. Amendments suggested by the people's elected representatives can be submitted to the people or their selected agents for ratification. That method of change was good for our fathers, and being somewhat old-fashioned, I must add it is good enough for me, and so I cannot rely on the Due Process Clause or the Ninth Amendment or any mysterious and uncertain natural law concept as a reason for striking down this state law. The Due Process Clause, with an arbitrary and capricious or shocking to the conscience formula, was liberally used by this court to strike down economic legislation in the early decades of this century, threatening, many people thought, the tranquility and stability of the nation. That formula, based on subjective considerations of natural justice, is no less dangerous when use of force is no less dangerous when used to enforce this court's view about personal rights than those about economic rights. I had thought that we had laid that formula as a means of striking down state legislation to rest, and for all in cases like West Coast Hotel Company v. Parrish, Olson v. Nebraska, Western Reference v. Bond Association, and many other opinions. In Ferguson v. Scrupa, this court 2 years ago said in an opinion joined by all the justices but one that the doctrine that prevailed in Lochner, Coppage, Atkins, Burns, and like cases, that due process authorizes courts to hold unconstitutional when they believe the legislature has acted unwisely, has long since been discarded. We have returned to the original constitutional proposition that courts do not substitute their social and economic beliefs for the judgment of legislative bodies who are elected to pass laws. And only 6 weeks ago, without even bothering to hear argument, this court overturned Tyson and Brother v. Banton, which had held state laws regulating ticket brokers to be a denial of due process of law. Only 6 weeks ago, without even bothering to hear argument, this court overturned Tyson and Brothers v. Banton, which had held that state laws regulating ticket brokers to be a denial of due process of law. Gold v. DiCarlo. I find April's holding hard to square with what my concurring brethren urge today. They would reinstate the Lochner, Coppage, Adkins, Burns line of cases, cases from which this court recoiled after the 1930s and which had been, I thought, totally discredited until now. Apparently, my brethren have less quarrel with state economic regulation than former justices of their persuasion had. But any limitation upon their use of natural law, due process philosophy to strike down any state law dealing with any activity whatever will obviously be only self-imposed. In 1798, when this court was asked to hold another Connecticut law unconstitutional, Justice Iredell said, "It has been the it has been the policy of all the American states which have individually framed their state constitutions since the Revolution, and of the people of the United States when they framed the federal Constitution, to define with precision the objects of legislative power and to restrain its exercise within marked and settled boundaries. If any act of Congress or of the legislature of a state violates those constitutional provisions, it is unquestionably void. Though I admit that as the authority to declare it void is of a delicate and awful nature, the court will never resort to that authority but in a clear and urgent case. If, on the other hand, the legislator of the Union or the legislator of any member of the Union shall pass a law within the general scope of their constitutional power, the court cannot pronounce it to be void merely because, in their judgment, contrary to the principles of natural justice. The ideas of natural justice are regulated by no fixed standard. The ideas of natural justice are regulated by no fixed standard. The ablest and purest men have differed upon the subject, and all that the court could properly say in such event would be that the legislature, possessed of an equal right of opinion, had passed an act which, in the opinion of the judges, was inconsistent with the abstract principles of natural justice. I would adhere to that constitutional philosophy in passing on this Connecticut law today. I am not persuaded to deviate from the view which I stated in 1947 in Adamson v. California. Since Marbury v. Madison was decided, the practice has been firmly established, for better or worse, that courts can strike down legislative enactments which violate the Constitution. This process, of course, involves interpretation, and since words can have many meanings, interpretation obviously may result in contraction or extension of the original purpose of a constitutional provision, thereby affecting policy. But to pass upon the constitutionality of statutes by looking to their particular standards enumerated in the Bill of Rights and other parts of the Constitution is one thing. To invalidate statutes because of application of natural law deemed to be above and undefined by the Constitution is another. In one instance, courts proceeding within clearly marked constitutional boundaries seek to execute policies written into the Constitution. In the other, they roam at the will in the limitless area of their own beliefs as to reasonableness and actually select policies, a responsibility which the Constitution entrusts to the legislative representatives of the people. The late Judge Leonard Hand, after emphasizing his view that judges should not use the due process formula suggested in the concurring opinions today, or any other formula like it to invalidate legislation offensive to their personal preferences, made the statement with which I fully agree that, for myself, it would be the most irksome to be ruled by a bevy of Platonic guardians, even if I knew how to choose them, which I assuredly do not. So far as I am concerned, Connecticut's law as applied here is not forbidden by any provision of the federal Constitution as that Constitution was written, and I would therefore affirm. Mr. Justice Stewart, with whom Mr. Justice Black joins dissenting. In 1879, Connecticut has had on its books a law which forbids the use of contraceptives by anyone. I think this is an uncommonly silly law. As a practical matter, the law is obviously unenforceable, except in the oblique context of the present case. As a philosophical matter, I believe the use of contraceptives in the relationship of marriage should be left to personal and private choice, based upon each individual's moral, ethical, and religious beliefs. As a matter of social policy, I think professional counsel about methods of birth control should be available to all so that each individual's choice can be meaningfully made. But we are not asked in this case to say whether we think this law is unwise or even asinine. We are asked to hold that it violates the United States Constitution. and that I cannot do. In the course of its opinion, the court refers to no less than 6 amendments to the Constitution: the First, Third, the Fourth, the Fifth, the Ninth, and the 14th Amendment, and the 14th. But the court does not say which of these amendments, if any, it thinks is infringed by the Connecticut law. We are told that the Due Process Clause of the 14th Amendment is not, as such, the guide in this case. With that much, I agree. There is no claim that this law, duly enacted by the Connecticut legislature, is unconstitutionally vague. There is no claim that the appellants were denied any of the elements of procedural due process at their trial, so as to make their convictions constitutionally invalid. And as the court says, the day has long passed since the Due Process Clause was regarded as a proper instrument for determining the wisdom, need, and propriety of state laws. My brother Harlan and White, to the contrary, we have returned to the original constitutional proposition that courts do not substitute their social and economic beliefs for the judgment of legislative bodies who are elected to pass laws. As to the First, Third, Fourth, and Fifth Amendments, I can find nothing in any of them to invalidate this Connecticut law, even assuming that all those amendments are fully applicable against the states. It has not even been argued that this is a law respecting an establishment of religion or prohibiting the free exercise thereof. And surely, unless the solemn process of constitutional adjudication is to descend to the level of a play on words, there is not involved here any abridgment of the freedom of speech or of the press or the right of the people to peaceably to assemble and to petition the government for a redress of grievances. No soldier has been quartered in any house. There have been no search or seizure. Nobody has been compelled to be a witness against himself. The court also quotes the Ninth Amendment, and my brother Goldberg's concurring opinion relies heavily upon it. But to say that the Ninth Amendment has anything to do with this case is to turn somersaults with history. The Ninth Amendment, like its companion the Tenth, which this court held, states but a truism that all which is retained, which states but a truism that all is retained which has not been surrendered, was framed by James Madison and adopted by the states simply to make clear that the adoption of the Bill of Rights did not alter the plan that the federal government was to be a government of express and limited powers, and that all rights and powers not delegated to it were retained by the people and the individual states. Until today, no member of this court has ever suggested that the Ninth Amendment meant anything else, and the idea that a federal court could ever use the Ninth Amendment to annul a law passed by the elected representatives of the people of the state of Connecticut would have caused James Madison no little wonder. What provision of the Constitution, then, does make this state law invalid? The court says it is the right of privacy created by several fundamental constitutional guarantees. With all deference, I can find no such general right of privacy in the Bill of Rights in any other part of the Constitution or in any case ever before decided by this court. At the oral argument in this case, we were told that the Connecticut law does not conform to current community standards, but it is not of the function of this court to decide cases on the basis of community standards. We are here to decide cases agreeably to the Constitution and the laws of the United States. It is the essence of judicial duty to subordinate our own personal views, our own ideas of what legislation is wise and what is not. If, as I should surely hope, the law before us does not reflect the standards of the people of Connecticut, the people of Connecticut can freely exercise their true Ninth and Tenth Amendment rights to persuade their elected representatives to repeal it. That is the constitutional way to take this law off the books. Well, that was a good read. And as always, if there's any case you'd like me to read, just drop one in the comments, and I'd be happy to take a look. Thank you.